What if I told you that when you discharge a debt, you're not actually running from it, you're fulfilling it in a lawful way? In this video, I'm going to be breaking down why debt discharge is an avoidance, how it's a performance by law, and why the system doesn't want you to know the difference. Now, I've studied UCC codes, banking regulations, and contract law, and I'm here to show you how to meet your obligations without falling into the trap of fear and misinformation. Now, before we dive into this video, make sure to hit the like button. If you hit the like button, this is actually going to help the algorithm to see content just like this. If you want to be able to help others, right, and have more people learn this information and get out of this space of fear and misinformation, go ahead and hit that like button. That's the simplest thing that you can do. Also, at the same time, share it with share it with 3 people that you know that may be interested in this content. Okay. This is how we get the word out. Okay. This is how we boost pages like this. That's going to promote the truth. Okay. No more of us like being in a space where we don't know what this economy is and we're just feeling like we're in this rat race or this trap, or we only can go about life in one way. There's multiple ways to be able to go about life, and it's not always in the way that you are being told by those higher powers. Okay. And I'm not talking about God. I'm talking about those people right beneath God. If anything, they're probably lower than that. If we want to be spiritual, you dig me? I think that anybody that's on the space of taking the information to help others are the closest thing. Okay. Now, let's dive straight into it. When people look at debt discharge, they think that it's a escape, but it's not. Okay. And most of the times I tell people, well, actually, before we dive into this, I want you guys to know that this is not legal advice. This is only for educational purposes only. All my rights are reserved. So make sure that you guys are doing your due diligence. If you decide to employ these strategies, I take no liability to it. Okay. So make sure you educate yourself and cross-reference everything that I talk about. Take notes. Make sure you got your notebook and notepad right now. You dig me? So that you can get this game, okay, and be able to attain this game. They say that after you watch something, you lose the information 25% each day. You are not tapped back into the information, okay? So now let's dive straight into it, okay? It's not an escape, you guys. Stop thinking that going debt discharge is an easier route than just paying your debt. You get what I'm saying? This is specifically for a person that doesn't want debt to affect them negatively, okay? By either using the administrative process that I'll talk about, or by being able to get out of this space of, man, I'm in debt, so I can't do anything. I spoke with a client the other day, and he said that, he felt like he was stuck. He felt like he was just frozen because of how much debt that he had. But really what needed to happen was that mindset needed to be shifted. Okay. When you think that debt is something that you can't go forward unless you pay it, then yes, you're going to feel frozen. You're going to feel like every single dollar that you make has to go to the credit cards or to your loans and things in that nature. Now, I will tell you, look, man, if there's a loan out there that you want to keep a relationship with, do not do this. You dig me? Not in the case of it wouldn't work, and there aren't banks out there that would be move in honor, but you got to be careful. Okay, they're tyrants at the end of the day, and they'll do anything in their power to get you to pay. Now, if it's a debt that if it's a debt that you don't care for their relationship, then by all means do what you got to do. If it's already charged off, do what you got to do. If it's already in collections, do what you got to do. Dig me? So the whole point of me teaching this right now is so that you guys can understand that there's multiple ways out. Now, debt discharge is a lawful fulfillment of an obligation. And all of this you can see and find in the law. Okay? We'll even talk about those laws today if you haven't already watched my videos. Okay? The system portrays it as dodging to keep people compliant. See, it's all a mental game. It's chess. They're trying to make you think that you can't do this, or make you think that they try to put a negative light on it. But the reality is it's an actual lawful way to fulfill an obligation. It's probably very similarly to paying it. The only thing is when you pay, they make more money from you paying. They don't make they don't make a lot of money from you just discharging, because they're going to get exactly what they're owed. You get what I'm saying? Quote unquote. All right. In truth, you're satisfying the obligation through a different channel. The whole point of it is a contract system. So as long as you satisfy the obligation, then you are in honor. Okay. So you're honoring the agreement, but on lawful terms. Okay. You're not honoring the agreement based on what they wanted you to do. Obviously, they want you to pay, but that's not the only way that you need to. Okay. And that's where the fraud comes, because they don't tell you that this is another way to fulfill your obligation. Okay. When it's a contract, the obligation just needs to be fulfilled. It doesn't need to be paid for, or it doesn't have to be in the way that they always want it to be. Okay. As long as you fulfill your obligation, you are in honor. Okay. So understand that performance isn't about how you pay. It's about satisfying the obligation. Get that through your thick skull. You dig me? If you can get that through your thick skull, then everything that I talk about today is going to make complete sense. Now, let's just dive straight into the laws. Okay. Now, one of the first laws I like to talk about is the tender of payments. Okay. And I bring up these laws, and some of you guys who watch every single video that I post, you'll see that I bring up the laws so that you have seen before. And here's one of my key philosophies. Truth is not the persuader. Repetition is. So if I constantly repeat that these laws are literally put in place, then you will understand how to actually discharge debt. Okay. It's not about a form. It's not about a proper way to do it. It's about really shifting everything onto them. And when they make them discharge the obligation themselves. You dig what I'm saying? And then you enforce that the debt is settled. You enforce their standing to be able to collect on a discharged debt. You dig what I'm saying? So now we go to UCC 3-603, and this is governed by the principles of law applicable to the tender of payment under a simple contract. Okay? So if a tender of payment of an obligation to pay instrument is made to a person entitled to enforce the instrument, and the tender is refused, there is discharge. Okay? There is discharge, and you can go on and read the rest of it yourself. Long story short, you want the refusal. Okay? A lot of people say, well, I sent my tender of payment and they refused it. Great. If they refuse it, what do you think you got to do? Dig me? You should challenge them. You should send them we'll get into that. Okay? You'll send them a evidence of dishonor. Okay? Or you just say, hey, in your letter, in your tender of payment, your notice of tender, you say that, hey, if you refuse this, then the obligation is satisfied. You tell them that in the letter. So they're going to think twice before they just refuse it and think that you're not going to hold them to that you're not going to use the actual law, UCC 3-603. You want to quote this law. You want to say, hey, look, my baby, when I send this to you, if you refuse it, it's going to be discharged by the operation of UCC 3-603. So if I were you, just know that there's no way you're getting out of this. Okay? Then we dive into after you discharge it, just know you have defenses and claims and recoupment. So long story short, under UCC 3-60305, if there's a chance where there's a lack of consideration, fraud, meaning they try to say that you did not discharge it, or they try to say that you can't discharge it, or long story short, or they can't even prove that they are the holder in due course. They cannot prove that they loaned you money, right? And they try to collect on something that they cannot prove anything on. You can defend yourself against that. That is the aspect of UCC 3-305. And this dives into the evidence of dishonor. If you send in a lawful tender and they refuse it, you can essentially highlight that this is evidence of dishonor. Okay, so if I'm lawfully doing something and you tell me I can't do it, that's dishonor. That is fraudulent. That is misleading information. You are ignoring what it is that your duty is. Okay. Then we have questions of what's a 1099-C? A 1099-C is something that is filed by a financial entity for each debtor for whom you canceled 600 or more of debt owed to you. Okay. So long story short, If a company fills out a 1099, and this is another way that you can get them to discharge it themselves. If you decide to stop paying your debt, just know they're going to fill out this form. When they fill out this form, they get paid as this becomes a taxable income to them. So the debt is settled if they file a 1099-C. They file a 1099-C. This is something that is, settles the debt. It discharges the debt. And the definition of discharge means to transfer from one obligation to the next. Now, originally in the beginning, you were taught that you can send this off yourself, and you can, but you have to come from a different angle when you decide to send this yourself. You have to prove that you were the person that loaned the money and created the money. And I'll just say that sometimes, yes, you can file a 1099-C, and you can get you can file a 1099-C, and you can get an acceptance for your 1099-C, but you have to fill this out properly, and you have to give reasons or be able to explain why you was able to do this. Okay, which is much harder than just letting them do it and then holding them to that. Because if they file a 1099-C on your behalf, you ask them for the copy B, the proof that they discharged the debt. You take this copy B and you send this to the credit bureaus. You dig me? If they decide not to give this to you, then they are violating the Truth in Lending Act. They are violating 9-210. They're violating anything in regards to secure transactions, where they have the duty to provide all the disclosures and inform you of all your credit uses. You know what I mean? So that's the power of the 1099-C. If it's charged off, that means they filled out this form and canceled your debt for you. Dig me? So usually they do this and then they sell it off to a debt buyer or a collection agency. So typically, if it gets sold off to a collection agency, you want to do the due diligence and see if they filed a 1099-C on your behalf and then sold it to a collection agency for double recovery, which is illegal. All right, so that's the 1099-C. Then we want to talk about 31 USC 5118. Okay, as a matter of fact, let's go to 5103. Okay, which breaks down what legal tender is. Okay, as a matter of fact, let's pull up tender in law. Okay, it says tender is to unconditionally offer money or performance to meet an obligation. Nowhere does it say to pay money. Okay, and it doesn't take out performance. Performance doesn't mean pay. Okay, I can even bring up the definition of pay. When you look at the law dictionary, it says the definition of payment is the performance of a duty, promise, or obligation, or discharge of a debt or liability by the delivery of money or other value. You know what I mean? You can only laugh because it doesn't say the money payment is when you use your dollars. It doesn't even say anything about a dollar. It doesn't even say anything about a Federal Reserve note. It says a performance of a duty, promise, or obligation, or discharge of a debt. So listen, my baby, if you want me to pay for something, my baby, oh, of course, I will discharge that debt wholeheartedly. That it just kills me when I see this stuff because it's right there. Okay, so let's go to 5118, where they pretty much broke down the ability for you to pay in gold. Okay, and this is where this goes hand in hand with House Joint Resolution 192. This goes hand in hand with the suspension of the gold standard. But the key thing that I want to point out is, number one, it says the definition of public debt obligation means a domestic obligation issued or guaranteed by the United States government to repay money or interest. So the key thing is, boom, issued or guaranteed. That sounds like insurance. Okay, so it says that public debt obligation is insured by the United States government to repay money or interest. So long story short, any domestic obligation is under the guarantee of the United States. Then we dive into one of the things that people don't talk about. The United States may not pay out any gold coin. A person lawfully holding United States coins or currency may present the coins and currency to the Secretary of State, Treasury, for exchange, dollar for dollar, for the United States coins or currencies that may be lawfully held. So long story short, this is when they actually had people surrender requisitions and they seized, okay, and they acquired all all the coins or currency, gold, silver, involving the effect or validity of a change in the metallic content of the dollar or in regulation about the value of money. Long story short, they made us surrender the gold. They seized the gold. They acquired all the gold. And that's what the Secretary of Treasury has. Okay. Then we dive into 31 USC 5103, which breaks down legal tender. I bring up this law because it just explains that the Federal Reserve note is the legal tender for all debts, public charges, and taxes, but it does not say that it's the only legal tender. Okay? And then we dive into 18 USC 8, obligations or other security of the United States. The term obligation or other security of the United States includes all bonds, certificates of indebtedness, national bank currency, Federal Reserve notes, Federal Reserve bank notes, coupons, United States notes, Treasury notes, gold certificates, silver certificates, fractional notes, certificates of deposits, bills, checks, drafts for money, drawn by or upon authorized officers of the United States, stamps, and other representatives of value or of whatever denomination issued under the Act of Congress and canceled United States stamps. So there's a lot there, but I love the fact that it doesn't just say Federal Reserve notes. Okay? Any obligation that includes all bonds. Okay? A bond is not a Federal Reserve note. Certificate of indebtedness. A 1099-C is a certificate of indebtedness. Okay. National bank currency. Okay. That can be the dollar. That can be coins, whatever the case may be. Federal Reserve notes. Federal Reserve bank notes. Coupons. We talk about this. Okay. United States notes. Treasury notes. Gold certificates. Silver certificates. Fractional notes. That's the same as Federal Reserve notes. Certificates of deposit. So if there was a deposit in your account, that's also of the obligation of the United States. Most people don't know the definition of deposit means a unpaid balance. You know what I mean? Bills, checks, drafts, drawn by or upon authorized officers of the United States. Most people don't know that if you have an SSN unit within the United States, you are an authorized officer of the United States. All right. So now that we kind of covered the law, that's kind of more like the meat and potatoes. But let's just tap into how the system performs without telling you, okay? Even though we went through this a little bit, but just to break it down, banks discharge their losses through insurance claims, like I just showed you. They also file 1099-Cs, okay? And they also sell your debt to debt collectors. You know what I mean? So they make it in 3 different ways, okay? And we're not even counting the fact that they make money off the initial promissory note when they sell it off as a financial asset. Okay, big corporations settle, discharge, and offset debt regularly. So when you look at the Donald Trump, when you look at those big corporations, and you're like, okay, well, do they use these strategies? Absolutely, absolutely. Okay, they even communicate via trust. Okay, this is why they're able to grow their wealth even more. But the public is trained to only think cash and ongoing payment equals honor. Okay, that's not the only way to be honorable. If you want to be real, it's more honorable for you to actually discharge your debt and settle it properly. Okay, they corporations and banks, they use lawful payments daily, but want you to be stuck in payments because it's beyond. They don't really care much about the money. They're going to get paid regardless. It's just the matrix. Okay, they want you to understand this exchange. They want your energy. They want you to continue to give your time, labor, and attention to work so that you will work for the almighty dollar and give it to them and repeat the same cycle. Okay. Now, here's what lawful performance looks like. Number 1, you would send a lawful remittance instrument like a coupon or a bond. Okay. You will also equip that with a notice of tender letter offering tender of payment, lawful instrument, money order. Okay. So when you do that, you're going to also quote UCC 3-603. Okay. Once you read this, you'll understand exactly what to put in that letter. Okay. Then you want to issue an affidavit of truth. The affidavit of truth is a statement of facts, pretty much of what you know to be true as it pertains to this contract. Okay. Who you are, where you feel like you got lack of disclosures, and what you know now. Okay. And you want to put out there that, hey, look, if this goes unrebutted, then this stands in truth when it comes to the law. You want to also send a conditional acceptance demanding validation and lawful accounting. What a conditional acceptance is hey, look, if you can prove X, Y, and Z, then I'll agree. Okay? The results in you doing this, you perform, you remain in honor, and they must prove non-performance or accept the discharge. See, that's the beauty about it. They're going to try to say you didn't perform. They're going to say you didn't pay, but you're going to come back and say, did I perform? And they're going to have to prove that you did not perform on a contract that they'll say that you defaulted on. If you didn't actually not perform on a contract, then they can't enforce it. They will have to prove that what you did wasn't a performance. And that's the beauty about employing these strategies is it's not about you sending it in the right way. I mean, yes, that is important, but if you know how to execute the process via performance, then they have to go either which way. Either you're going to prove my non-performance, and if you can prove it, then yes, I'll agree to pay, or you just accept that it's discharged, and you have my account reflect the ledgering of said sender, okay? So understand that you're not refusing to pay. You're just choosing how to lawfully settle the obligation. And you have a choice beyond that. That is your God-given right. Okay. So here's why knowledge equals the freedom. Okay. Because understanding this frees you from the fear of debt. Okay. If you ever get in a situation where you feel like you can't pay back debt and you have no other choice, just know you can fulfill it in any other way. Now, I'm not telling you to do this for situations where it may affect your living situation, your heat, this, that, and the third. Obviously, I'll be very strategic with those things. But when it comes to credit card debt, when it comes to loans, when it comes to, things like that won't have an immediate adverse effect other than it'll affect your credit report, this is something you don't have to fear. Okay. Knowing your options empowers you to negotiate, discharge, and defend. So no more feeling like you are stuck in a rut or that you have debts after debts after debts that you have to pay. And the law protects those who move first in honor and with paperwork. Okay? You're not a rebel for using a law. You are a responsible citizen protecting your energy. So you actually employing discharging is actually responsibility. You being responsible. Okay, you did your due diligence and you're deciding to do your you're deciding to perform in a different way, and they will have to prove that your performance is something unlawful, which they cannot do. Okay, but if you're a person that think that you're just going to send in a letter and this, that, and the third and not going to have to fight with them, or you're expecting them to just immediately go along with what you say and you cannot put them in their place, then don't do this. Okay, so understand that discharge is not about dodging your responsibility. It's about performing smarter, not harder. And once you move in honor, they can't use fear to control you anymore. Okay? The biggest thing that keeps us from employing these strategies is fear. Okay? We think that something bad will happen if we do this. But what if it hurting your credit report wasn't something that was that bad? If you're not applying for anything, if you're not looking to get credit within the next 12 months, then employing these strategies are not that bad. Okay? If you're going to be consistent, if you're going to send them a letter every month and respond back to their letters and take them through the process, then there's nothing to fear. If you're just going to send them a letter and then leave it up to chance, then yes, you have something to fear. If you don't understand the knowledge behind this and you're not willing to do your due diligence to learn it on your own so that you can be able to not be fearful, yes, you're going to continue to be fearful. See, the knowledge and the education is what's important. This is why I talk about it in this video, because I want to break that fear that y'all have. Okay? This is not something that you have to pay for. If you sat there and watch every single video, you'll be able to break that fear. Okay? That's the whole point of this channel, to put you guys in position to start exercising these things and become a responsible citizen. You dig me? Also, I'm not biased. Okay, look, if you can pay your debts, pay it. But if it gets overwhelming, just know you have other options. That's the whole point. Even if you decided, hey, look, man, I'm going to stop paying this credit card. Yes, it's going to ding your credit report, but that's okay. Really, your credit score goes down. So what? Are you applying for anything? What usually happens when we start caring about our credit report is when we want to start applying for something. But if you start getting ahead of the game now, you say, okay, within the next 12 months, the next 1 or 2 years, I'm going to be, I want to start applying for X, Y, and Z. I want to get a new car, or I want to get a home or something like that. You start employing these strategies now. You start learning. You start doing the due diligence now. You start doing some of the work now. And, you perform on your contract up until then. If it works, it works. If it doesn't work, it doesn't work. The next thing that they'll do is, hey, look, we'll file a lawsuit on you if you don't pay this debt. But if you get ahead of the game, you start moving first, and you say, before you go 2-3 months of not paying a debt, how about you send them a lawful tender? How about you send them a conditional offer? How about you send them an affidavit of truth before you decide to stop paying? If you don't understand these concepts, you don't understand how to put this stuff together, then continue to pay them. Because I'm not going to be the one to tell you to not pay something when you don't even know what to do. Because I don't want you to stop paying something out of emotion or what you feel is right. I shouldn't have to pay this debt. No, you shouldn't have to pay the debt, but you still have to perform on a contract that you signed. You dig me? So no, this is not an escape route. Okay? Doing the work or doing the due diligence and discharging the debt still takes the same amount of energy. Maybe it's different energetically, but it still takes the same energy that you'll put into going to work every single day. If you're not willing to put 8 hours a day into learning this, I won't say 8 hours a day, a minimum 1 hour a day, 30 minutes a day watching these YouTube videos so that you can have a full understanding, then you don't deserve to discharge debt. You get what I'm saying? If you're not willing to put that energy that you would put into your job into executing these processes, then you don't deserve this. If you're gonna go and work your job, and then after your job you're gonna say, I'm too tired to do this, I wish someone would just do it for me, you'll end up in a situation where you're going and asking people to discharge your debt for you. They don't want to go through this entire process, this negotiation process. I'll tell you, anybody on the market that's sitting there saying, hey, look, you can discharge your debt, I'm gonna send you these forms and boom, this is how you're gonna do it, I don't even have to say it. Okay, because in the way that I'm teaching you right now, it's no way that you can just send in a couple forms, right, at one time and your debt is going to be discharged. Just know it's a full process, a whole administrative process. And this is something that's going to be more useful than just sending in a couple forms and hoping that that bank is just going to comply. Let's just say you send those forms in and the bank doesn't comply. What are you going to do then? What if you send those forms to the credit bureaus? They don't even understand what these forms are for. What are you going to do then? See, your paperwork is going to tell the story. Your paperwork is going to say, okay, this is exactly what happened. And when you start to show this evidence to the credit bureaus, the CFPB, or you end up going to court for something, they will have to then prove that whatever you did wasn't you moving in honor. And that's all it's about. Now, if you want to learn more about this, down below, I have the Complete That Guide. The Complete That Guide breaks down everything that I talk about. I honestly would tell you, you can watch all my YouTube videos. But let's just say you wanted the templates. Let's just say you wanted the resources. Let's just say you wanted more of a deep dive. Go ahead and grab the Complete That Guide right now. It's down below. Link is in the description. You'll have it for a lifetime. Dig me? I'm not even going to say the price. You go and check out the price yourself. It does cost money. You feel me? It's not free, given the fact that I do put in work and add items to that every single time I drop a video. But beyond that, go ahead and grab it. All right. Second thing, if you want to work with me one-on-one, okay, and you want to understand the aspect of, you want to be able to fix your credit, you want to be able to get funding, and you want to be able to build wealth, go ahead and tap into that one-on-one mentorship. Okay. At this point in time, if you're looking to understand how to lawfully perform and you need a coach, someone to give you guidance, notice I'm not going to be doing it for you. Okay, we're going to be doing it towards a purpose, and I'm going to help you understand these concepts. Go ahead and tap into that one-on-one mentorship. Okay, and lastly, follow me on Instagram for daily commercial law and credit game. Okay, at biz.nick on Instagram. Okay, and my last question is, have you ever tried discharge or tender performance and got resistance? Drop your experience below. Remember to like, subscribe, turn on the post notifications, because the law is your weapon when you understand it. If you got all the way to the end, comment the word discharge, and I'll see you in the next one.